Efforts to ban or restrict books at America's libraries hit a record high last year, according to a new report from the American Library Association.
The conflict over religion in American public schools. It is a live, intensely litigated battle playing out in communities across the country. On the surface, these disputes often appear as simple, localized disagreements. Yet, an in-depth analysis reveals they are flashpoints in a much larger ideological war. The stakes extend far beyond the specific case at hand, touching upon fundamental questions of constitutional law, historical interpretation, and the very nature of public education in a pluralistic society. A recent case involving a high school senior in New York provides a compelling starting point for this exploration. The student, Sabrina Steffens, sought to paint a Bible verse and other religious imagery on a paid parking space at her public school, a tradition that allows seniors to express themselves for a fee. When the school initially rejected two of her designs due to their religious content, the situation escalated. A religious liberty law firm, the First Liberty Institute, intervened, threatening litigation. Confronted with the prospect of a costly, legal showdown, the Grand Island Central School District quickly reversed its decision, allowing the student to proceed with her original design. This incident, while seemingly a small victory for an individual student, illuminates the powerful dynamics at play. The confrontation was not resolved by a court ruling, but by the immediate threat of legal action. This outcome underscores how well-funded and strategically organized advocacy groups are influencing the behavior of public institutions. By leveraging constitutional arguments and the high cost of litigation, these organizations can effectively enforce their interpretation of religious liberty without a single judge's order. This tactic demonstrates a powerful causal relationship between the rise of litigious advocacy groups and the cautious, often risk-averse decision-making of public school districts across the United States. While individual student battles are a key feature of the modern conflict, the issue has also expanded to the state level. These legislative efforts are widely viewed as a bold, unequivocal move to re-establish religious symbols and texts within the public education system. However, the narrative of a triumphant return of religion to the classroom is incomplete. The truth is far more complex and legally precarious. The legal push to mandate 10 Commandments displays has been met with a surprising and consistent counter-narrative from the federal judiciary. Federal judges in Texas and Arkansas have temporarily blocked the implementation of these laws, issuing preliminary injunctions that prevent school districts from enforcing the mandates. A federal judge in Texas explicitly noted that the law likely violates the First Amendment's establishment and free exercise clauses and could lead to unconstitutional religious coercion of young children. The judge's ruling also pointed out the potential for teachers to feel compelled to answer students' questions, blurring the line between passive display and religious instruction. This direct clash between legislative will and judicial precedent reveals a critical tension in the current legal landscape. While a political and cultural movement is pushing for these laws, the federal court system is, for the time being, upholding decades of established constitutional law. This ongoing legal battle, which is expected to reach the Supreme Court, is a defining element of the modern culture war and its unpredictable trajectory. The public discourse surrounding religion in schools is often defined by a common misconception that the Supreme Court banned the Bible and prayer from public education. This framing, however, overlooks the nuanced and protective nature of the landmark rulings that shaped the modern debate. the key to understanding. The current controversy lies in the origin of these decisions, which began in the early 1960s. Before these rulings, state-composed prayers and Bible readings were common, if not mandatory, practices in many public schools. The legal landscape changed dramatically, with two seminal Supreme Court cases. First, Engelver Vitale, 1962, addressed a non-denominational government-written prayer in New York schools, ruling its recitation unconstitutional, as it violated the Establishment Clause. The following year, Abington School District v. Jimp, 1963, expanded this precedent, invalidating mandatory, daily Bible readings and the recitation of the Lord's Prayer in public schools. The fundamental purpose of these rulings was not to eradicate religion from public life, but to prevent government entities from sponsoring or promoting religious devotion. The court's reasoning centered on the idea that government-led prayer and Bible reading, even if officially voluntary, created a coercive environment for children and could pressure students to conform to religious practices that conflicted with their private beliefs. This legal standard was rooted in a foundational principle of neutrality. The court did not prohibit the Bible itself, but instead distinguished between two distinct activities: teaching for religious indoctrination and teaching about religion, objectively, as part of a secular educational program. In fact, the court explicitly noted that the study of the Bible, for its literary and historical qualities, is not only permissible, but can be a valuable part of a complete education. The so-called Bible ban is therefore a profound misnomer. The rulings were a ban on state-sponsored prayer, intended to safeguard religious freedom for all students, including those of minority faiths and those with no religious affiliation. Another common assertion in this debate is that the modern secularism of public schools represents a fundamental deviation from the principles of the nation's founding fathers. This argument, which suggests the founders intended for a Christian nation, is undermined by a close examination of their complex and varied beliefs. Many of the key figures in the nation's founding, including Benjamin Franklin and Thomas Jefferson, were deists who held a rationalistic view of the universe and rejected central tenets of Orthodox Christianity, such as the divinity of Jesus and the biblical account of miracles. However, the most compelling evidence for a separationist view comes from James Madison, often called the father of the Constitution. Madison, though a person of faith, was a staunch advocate for separating government from religious matters. He explicitly warned against taxpayer funding of religion, believing it would lead to a corruption of both the state and the church. Thomas Jefferson, in his famous letter to the Danbury Baptists, used the metaphor of a wall of separation between church and state to describe his view of the First Amendment. The founders' commitment to this wall was not an act of hostility toward religion, but a pragmatic and philosophical stance to protect it. They understood the long history of religious persecution and conflict that had plagued Europe when church and state were intertwined. This historical reality was reinforced in early America, as exemplified by the 1844 Bible riots in Philadelphia, where conflicts over which version of the Bible to read in public schools led to violence and the destruction of churches. The founders' principles, therefore, were not a call for the state to impose a singular religious identity, but a bold, revolutionary move to create a government that would be neutral in matters of faith, allowing a diverse array of religious beliefs to flourish without fear of government coercion or persecution. The legal and cultural battles over religion in schools are entering a new, more complex phase. While the old conflicts over mandatory prayer and Bible reading persist, the focus is now shifting to more nuanced issues, largely influenced by a new conservative majority on the Supreme Court. Recent rulings, rather than simply overturning old precedents, are creating a new legal framework that complicates the balance between the Establishment Clause and the Free Exercise Clause. For example, the Supreme Court's decision in Kennedy v. Bremerton School District 2022 ruled that a public school football coach had a right to engage in personal prayer on the field after games. This decision, framed as a protection of a teacher's private religious expression under the Free Speech Clause, is viewed by some as a significant erosion of the Establishment Clause. These cases are not about a simple yes or no to religion in schools. Instead, they are pushing the boundaries of what constitutes governmental speech versus private expression and prioritizing parental rights and individual religious freedom over the state's interest in a uniform, secular curriculum. The result is a legal landscape that is no longer a rigid wall of separation, but a more permeable, and therefore more contested, space where the two clauses of the First Amendment are in constant and dynamic tension. This shift means future battles will likely not be over state-mandated prayer, but over whether a student's religious expression is protected and whether a parent can remove their child from a secular lesson. The current debate is also less about banning the Bible and more about the deeply controversial question of how the Bible is presented in a public school setting. Proponents of laws mandating Bible instruction often argue for its inclusion, for its immense literary and historical value, a stance that aligns with the Supreme Court's guidance. They contend that without a working knowledge of biblical stories and allusions, students are culturally illiterate and unable to understand vast swaths of Western literature, art, and history. Furthermore, they argue that failing to teach the Bible denies students a foundational understanding of the principles that shaped the nation's founding documents and legal framework. However, critics contend that these laws and curricula cross the line from academic education into religious indoctrination. The state-authored Bluebonnet learning curriculum in Texas, for example, is presented as an objective, secular program, yet critics, including a state lawmaker, have called its content preaching rather than teaching. These opponents point to the curriculum's emphasis on Christian teachings while reportedly omitting lessons on other major world religions such as Buddhism, Hinduism, and Judaism. The potential for teachers to blur the line between educational and devotional exercises remains a significant concern, especially when financial incentives are tied to the adoption of the curriculum. This highlights a fundamental divide. One side sees the Bible as an indispensable component of an American education, while the other sees state-sanctioned teaching of any religious text as an unconstitutional endorsement of a particular faith. The most critical and often overlooked voices in this debate are those of minority religious groups and non-religious families. Civil liberties groups, such as the ACLU and Americans United for Separation of Church and State, often represent a diverse coalition of plaintiffs, including Christians, Jewish families, and atheists who stand together against what they perceive as government promotion of a singular religion. For many Jewish families, public education is seen as a hallowed civic virtue and a sanctuary that has allowed them to thrive in America. They, and others, contend that religious instruction is the sacred and private duty of the family and religious community, not the state. The experience of minority faith students further underscores this concern. Research shows that Muslim students, for example, often face bullying and feel unwelcome in public schools due to their religious identity. The fear is that state-led efforts to mandate religious materials will exacerbate this feeling of othering and create an environment where non-Christian children feel pressured to conform or are isolated. This is a crucial point that reveals a deeper truth about the controversy. The battle is not just a political one between left and right, but a struggle for belonging and respect in a pluralistic society. The debate is about whether the public school system will serve as a unifying institution for all students, regardless of their background, or whether it will become a battleground for competing religious agendas. This analysis indicates that a government that is neutral in the field of religion best serves the interests of all faiths and citizens, a principle that, as the evidence suggests, was at the core of the Founding Fathers' vision. In conclusion, the claim of a school Bible ban is a profound simplification of a complex legal and historical reality. The ultimate question is not about whether the Bible belongs in public schools, but rather how it is to be understood as a tool for academic enrichment or a vehicle for religious instruction. The evidence shows that the conflict over the Bible is far more nuanced than the headlines suggest, serving as a powerful lens through which to view the ongoing American debate about faith, freedom, and the purpose of public life. The true controversy is not a ban at all, but a fundamental disagreement over who gets to define what the Bible means, both for individuals and for the nation as a whole.